Mike Harris back with What in the Law podcast. And today I'm going to talk about one of the more common issues that affects people generally, which is protection orders or restraining orders. Now, there are different types of these orders, but what I'm mostly going to talk about is a civil protection order where you are seeking no contact with somebody. However, before I do that, I want to talk about a couple other things. First is the words. We use in Colorado the word protection order. Restraining order is generally used in other jurisdictions, but it's basically the same thing. So that's why I use that word. But basically, when I say protection order or restraining order, they're the same thing. Secondly, I want to talk about if there is a criminal case going on. If there is a criminal case in Colorado, there is going to be, as part of that, a mandatory protection order. Now, that order might include no contact with a victim, or it might not. It just depends on the circumstances, what you are accused of, what the judge feels about it, and whether or not a victim wants a no contact order. But these are all general considerations. Ultimately, the judge gets that final say while that case is ongoing. One other limitation with the mandatory protection order in the criminal case is it only lasts while that case is ongoing. So once that case is complete and any sort of probation or jail or prison sentence or parole is complete, any protection order that was part of that case is also complete. Civil protection orders are a little bit different, and this also can be broken up into a whole bunch of different areas. But what I'm going to talk about right now is how to start with that process, or the temporary protection order. Basically, if you want a temporary protection order, you go into court, you sign an affidavit, you fill out some other information, and you go in front of a judge. What you have to explain is that something happened. It might be a criminal offense, like an assault, or stalking, or a phone harassment. It might be something that doesn't quite rise to a criminal offense, but is still very concerning, such as a threat, which in some cases might be criminal, or in other cases might not quite rise to the criminal level. In either situation, if the judge feels that you presented evidence that something had happened and that it is reasonably necessary for you to have this protection order to basically keep yourself safe, then the judge will issue a temporary order. During this initial hearing, the other side is not going to be present. It's basically just you. You could potentially bring someone, but normally the judge will just listen to what you have to say in that decision to give the temporary order. Once the judge issues that temporary order, the judge will set it for a hearing. In the meantime, your job is now to get that person served, or have that piece of paper of the protection order given to the other person, so that person knows when to go to court and knows that they're not allowed to contact you. The sheriff's office can normally do this for you, although legally any person who is over 18 years old and who is not a party to the case can accomplish this. And if you already are working with a lawyer, they can work with someone who is a process server, or you could hire someone. But again, most of the time you just do it through the sheriff's office. Now, once this service is accomplished, there will be that final hearing. And there are some different steps there, but that can be a little bit more involved. So we're going to do some other episodes in the future to talk a little bit more about what happens after you get the person served and you get to court for that hearing. I will point out one final thing, that if you get to your first hearing and you have not been able to get that other person served, the case is not over. Most judges are pretty reasonable. They will give you another opportunity and set the case for another court date and give you more time to accomplish that service, as long as you are doing something and hiring someone or getting the sheriff's office to make efforts to look for the person. So that's a little bit of a chunk of protection orders, and we'll talk a little bit more about some other steps that come after you get to that hearing and how that hearing would go in the future episodes of What in the Law podcast. In the meantime, if you need help, give me a call. I'm at 719-635-2005, or check me out at MikeHarrisLaw.com or all over social media. See you next time.